I haven't seen Conclave.
I mean, at least I didn't, make myself the Pope.
That's fair. Someone on the internet is now going to do that.
Yeah, that'd be awesome. That'd be awesome. I would frame that. I'd put that in one of the girls' bedrooms and just not tell them. Be like, here you go. Pope Rafi.
New Pope. We can say Uber in this particular case. Uber could say, well, we're not going to settle without confidentiality.
As far as we know, this is the largest non-confidential settlement in the country that we've ever heard of. I want to start with the idea that we have settled a lot of rideshare cases, a lot of rideshare cases over the years, and we've never been able to talk about them in detail. Okay? And that's because, and I'm using rideshare here purposely because I don't want to talk about the cases we settled that we can't talk about by even saying the name of the company, right?
Why is it that every time we talk about cases, it's always there's something we can't talk about our cases or settlements?
Because the companies don't want us to, and a lot of people say out there, like, why do you guys agree to confidential settlements?
That's better for our client.
Yeah, let's start there because that's the first part of this. We need to, because our interest in making videos, although I like doing this, is secondary to the client's interest in being fully and fairly compensated. And they're our boss. We work for them.
Yeah, absolutely. I mean, for the greater public, it's better that these aren't confidential. For the individual that's hurt, or the victim of a crime or whatever it may be, it's better for them to receive the compensation that they deserve, that they've probably needed for months, if not years, than to be able to talk about it.
Yeah. Do you remember the Walmart case where Walmart harassed that cop, tried to get him to lie and change his story?
Do I? I remember.
Hey, look, it's been a while. When I put that video up, the number one comment was, you should have taken it to trial and proven, all this. Well, one, Walmart doing that stuff doesn't add value to the case necessarily. The client's injuries are still the client's injuries. And the judge would tell the jury, you're supposed to compensate the client if you choose to for their injuries and their injuries alone, not because you're mad at another party.
Right.
So technically, the jury should not do that. Sometimes do juries do that? Absolutely. But the number one comment was, you should have done that. And my response was, no. Once we found out about this, took action, Walmart then said, oh shit, and gave an amount of money that our client could not refuse. It would be bad judgment for me to say to my client, no, you should not take that. You should say no, because when we go to trial, because Walmart was in such bad shape, you might get less. And what good does that do for the client?
Yeah, at the end of the day, people think our job is to go try a bunch of cases. Our job is to get the amount of money that our clients deserve for their injuries, regardless of how it happens. If it is putting pressure on the defendant corporation because they did something bad, and then all of a sudden they magically start valuing the case like they should, well, that's quicker than going to trial. That's better than going to trial because it can't be appealed, and we settle the case for our client. If we have to try the case to get that fair compensation for our client, that's what we do. But at that point, we would hope that we've either exhausted everything we could possibly do to get full, fair value for our client, or we've set ourselves up to the point where if we're at trial, we're going to get a really good number.
Yeah, I mean, if we had a choice, we would try every case.
Oh, yeah. That'd be way more fun.
Right. That's like nobody's, I shouldn't say no one. There are a lot of people. We didn't become this type of lawyer to be like, please settle, please settle, like go and beg like some other lawyers do.
Yeah.
But you try cases to not have to try cases. Like that's the reality. You try cases and you get good results. And then in your other cases that follow, lawyers and insurance companies on the other side go, oh yeah, we shouldn't try the case because look what happened over here. And then you don't have to. I mean, and clients benefit from that. No one comes into our office initially and it's like, I want to spend 3 years. I want to go through every hearing possible. I want to go through all the motions, and I will then want to have a trial. That usually isn't. I can't think of anybody, at least, that has ever said that at first. We get clients that harden over time, though, and get angrier as the time, not at us, angrier at the situation when we're like, yeah, that's going to happen. Then they want to go to trial. But usually at the start, they're just like, can we do something fair here? And we're like, oh, we'll try.
Right. And what makes them angry towards the end is that they haven't been treated fairly for so long.
Yeah.
And what I try and tell our clients is if you get mad and you get angry about this process, about the delay, the insurance company, the corporation, they're winning. because
I don't know if that's true. I just think it's a human reaction to be mad.
Well,
I'm mad all the time. I live my life mad.
It's fine to be mad. It's not good to be mad to the point where you make a bad decision because of it, right? And so if someone says, okay, I'm willing to accept less because of how long it's taken, well, that rewards the corporation for delaying. And they're making money on the money that they would otherwise be giving to our client during the entirety of the case. Our client has outstanding medical bills, can't work, isn't having income during that time period, and the bills are starting to stack up and stack up. So the delay is better for the corporation and the insurance company and much, much worse for our clients.
So back to why we can't talk about cases.
Okay.
So if you settle a case for $5, $10, $15,000, there's usually not a confidentiality agreement because it's $5, $10, $15,000. Nobody's going to run around being like, I just got $5, $10, $15,000.
There are some people.
All right, they shouldn't.
Not us.
They shouldn't. When you settle a case for a substantial amount of money, I'm talking, millions, then there's almost always a confidentiality agreement because the company and the insurance company says, we don't want you, lawyers and client, to run around saying, hey, we got all this money from the insurance companies. Even if they say they didn't do anything wrong, they obviously did because they gave us all this money. So they don't want us to talk about it. And rideshare companies are notorious for being probably the most aggressive with confidentiality agreements.
We see confidentiality agreements in cases we have against rideshare companies when we're talking about that 5 to 15,000. I mean, the lower value cases, they still want them to be confidential.
They won't even give an offer that isn't premised on the idea, that isn't conditioned that there will be confidentiality if you accept this offer. Like a lot of times you have negotiations and then as you kind of get closer, somebody then says, oh, hey, does this include confidentiality? Does it not? And then you start negotiating with that involved. They start from the premise of everything is confidential. Everything. So there's an exception to that. And I guess what should we call our client? What do you want to call him?
Let's call him Ben.
Ben? All right. Okay, I'm just internalizing that. So there is one exception that we've had. And now wait, I guess I can back up here. There are so many rideshare stories I would love to tell. We got the client who was walking across Centennial Olympic Park to the Waffle House there and got smashed by a rideshare driver and it was on video. I would love to show everyone that video.
Yes.
I mean, it's gruesome, but it is a great case to explain some pretty interesting issues. There are cases that we've had that clients have been passengers in rideshare services, rideshare vehicles, and those pose certain issues that I'd love to talk about. Can't. We're not going to end this video by telling you that we can't talk about anything. And that's because there's an exception. We have a client named Ben, not real name, that we can talk about, and we can talk about his case. So let's start with the idea of why we can talk about this case and how that works with the leverage that happened.
There's a special type of offer that we can send in Georgia cases, at least, that allows us to say, hey, we'll settle for this. And if we go to trial and we get a number from the jury that's 125% of that value, then you have to pay the attorney's fees and expenses. Doesn't matter how we calculate that. That's a whole nother video. But it puts pressure on the defendant to say, okay, we need to really consider this offer.
And they can do one back to us that if they send, well, I'm going to use the $1 million for an ease or $1 million for ease. So if they send an offer for $1 million and then we go to trial and we get less than $750,000, 75%, then we, our client, has to pay the other side's attorney's fees and expenses. And from our point of view, if we send that $1 million offer and we get more than 1.25 million, they have to pay the fees and expenses. So, and those can be very substantial. So it's a very specific special offer. We have to jump through a lot of hoops of how we draft it, how we send it, all that stuff. But once you send it, it's kind of like a, rubber meets the road offer. Like, what are you going to do right now?
And a lot of people in these offers, they include a settlement agreement or they include certain terms that they want to be included in the settlement. In this one, I knew it was Uber. We can say Uber in this particular case.
Uber.
Yeah.
What's interesting though, I got to get back to this. In other cases, when we settle confidentially, we cannot defame Uber. So I assume that still applies here.
Well, I think that's the law generally. You can't defame
Well, we can't
anyone.
disparage. We can't disparage. You can disparage people. and that's still legal. But in all other cases, it's not just confidentiality. Uber says you can't talk about the details of the case, you can't talk about the amount of the settlement, and you can't disparage us. You can't talk shit about them. So I want to be clear, we're not going to talk shit about Uber during this video. We're just going to say the facts and the strategy and how this works. I'm not going to say that Uber is extremely dangerous and that they don't vet their drivers, and that if you're a female especially, don't get in an Uber alone because that driver may not be vetted. I'm not going to say that. I'm not going to say that Uber supports tort reform in Georgia and sent, I guess I already have sent this, but they sent out an email to all their subscribers, everyone that rides their platform or uses their platform, saying, plaintiffs' lawyers are evil people. I made a video about how we are an Uber-free household now. So anyway, we're not going to disparage Uber in any way, because I think it's more that we did a really good job as opposed to them doing a bad job.
Yeah, I think so too. And in this case, when we sent this offer, we told Uber nothing about the terms that we wanted in the settlement agreement.
Well, we told them the important terms. We will dismiss the case.
We told them, in exchange for the policy limits, we will dismiss the case.
That seems fair.
Those
You
the
give
terms.
us money, the lawsuit's over.
Yeah.
What else do you need?
At the end of the day, that's what every settlement agreement should say. But because
they're talking about Medicare potential, it's talking about have you ever been bankrupt? Have you sold your lawsuit to anyone else? Like the terms, I think every settlement should be a page or less. I think almost everything in life should be a page or less.
And I know I'm about to trigger you on this, but there are terms that are in every single settlement agreement that say no matter what the settlement is for, the victim agrees to cover all the medical bills. So we've got a crash, let's say, where our client has $100,000 in medical bills. The only amount of insurance available is $50,000. The insurance company then wants to say, hey, but you'll make sure that you cover all these bills for $100,000 out of this settlement, right?
Maybe.
We can't.
Maybe. We'll try. We probably can, but we can't promise you.
Yeah. I mean, it's dependent upon each client's specific insurance coverage, where they went to go treat, whether the hospital that they went to is willing to be philanthropic.
My favorite part is who gets released. It's the first page of almost every release. So it starts with the recitals, which is, come now, hear ye on this date in this location herewith happened. And I'm like, we can do this in one sentence. There was a crash on Highway 2 on June 1st, 2022. That's what this settlement is about.
Right.
And then, but after that, it's not just our client releases, gives up their lawsuit in exchange for money. It's that our client, his heirs, his assigns, all people ever having a vested interest in his, I feel like through him, with him, in him, in the unity of the Holy Spirit. It's conclave. This is bad. Should I do it? Like, as a Catholic, should I do that?
I haven't seen Conclave.
I mean, at least I didn't, make myself the Pope.
That's fair. Someone on the internet is now going to do that.
Yeah, that'd be awesome. That'd be awesome. I would frame that. I'd put that in one of the girls' bedrooms and just not tell them. Be like, here you go. Pope Rafi.
New Pope.
We send that offer, the special offer, and our terms for settling the case are as simple as they can be. You pay us money. We stop suing you. And we won't sue you again, which is very different than what you typically see. And especially if you want the other side to settle, you're going to throw in terms that they want that we don't care about. Like, we'll pay the medical bills as best we can. We will, do whatever else needs to get done to settle the case. Those extra terms don't harm our client. We know that they just want them and it makes them feel good and sleep well at night, and then cross their boxes off when they're going through their checklist of, should we settle the case? But here, we didn't want them to accept the offer. I mean, right?
If they don't accept the offer, then we can go to trial and potentially get more. And the reason why we could potentially get more...
Or we could settle the case for more later when they kind of come to the idea of, that they were right. They say, hey, can we settle for that amount? And we go, oh, no, you got to add 25% to it. I mean, it's a bargaining chip as well.
And in this case, there were two people who were hurt because of an Uber driver's driving. They settled the first case really quickly.
And we didn't represent
that person.
Yeah.
And so they had $1 million in insurance limits for this crash. And so that reduced the amount that our client could get by a little over $100,000.
So let's call it 900 for easy numbers here as we go through this.
Yeah. Because the other driver had been injured, we weren't able to get that full million unless we did something in the case that allowed us to exceed the policy limits. And this offer was one of the ways that we thought of to say, okay, if we go get a jury verdict that says $1.2 million, there's a way in which they might not have to pay that. But if we set it up this way and we send our offer of settlement in this under this specific statute in Georgia, we have a better chance of recovering more than the policy limits.
I'm with you.
Yeah.
I agree. I obviously agree with this course of action that we took.
Yeah. It worked.
Yeah. So
Kind of.
So Uber has $1 million of insurance coverage if they cause the crash. And when multiple people are hurt, that $1 million just starts reducing by whoever settles with Uber. So we have one other person, they settle for $100,000. That million goes down to $900,000.
Right.
And then our client's the only other person that's hurt. So our client is saying, and he badly hurt, obviously, is saying, I'd like to get all of that money. And we're saying to him, yeah, but your case is worth more, we think. And we want to do some things to set you up that we might be able to get you more, or at least get you the best shot to get the 900 that is left on the insurance policy. And when you say policy limit, you mean the maximum amount of money you can get from the insurance company because of the policy that's available. Do you want to talk about Ben and Ben's injuries and everything?
Yeah. So
Ben was drunk.
Ben had too much to drink to drive.
Yeah. I like how you got nervous when I said Ben was drunk and you got like real nervous. Ben wasn't driving.
Right.
Okay.
No, he was not. Ben did the responsible thing. Ben was a passenger in an Uber because he'd gone to a party, he'd had a few drinks, wasn't safe to drive. That's what we want people to do. Go Ben. Ben was doing a great job.
Oh, I was celebrating how much he drank. Like good job, Ben. You know.
Well, I mean,
we can celebrate the other part too.
Yeah. So he gets into the backseat of an Uber to go home, and that Uber driver gets into a really bad crash and causes the crash. It's his fault. Nobody disputes that it's his fault. And Ben leaves that Uber to go to the hospital with a C-collar on his neck, scars on his head, scars on his hands. A C-collar is not like from one of those wrestling videos where they're just like...
Andy Kaufman.
Yeah, or Andy Kaufman, the comedian, where he's acting like he's hurt or he's trying to, convey that he's hurt when he's really not. A C-collar is a hard shell collar that stabilizes someone's neck before they're able to be evaluated to determine whether they have a fractured neck or something that's really, really bad.
C-collar is not like the thing you see in really bad movies, usually where lawyers are faking something or whatever.
Right.
It is a thing that you literally cannot move your neck.
And a lot of people have C-collars put on their necks immediately after a really bad crash and they end up being fine. Their neck is okay. But the reason why emergency medical responders put it on there is because you can have pain in your leg or your back that masks your neck pain. And if you move your neck in a way it's not supposed to move based on the injuries that have yet to be diagnosed, then you can make it way worse.
Well, and if you don't put on the C-collar and the paramedics are like, put this on, and you're like, no, I'll look stupid, or no, I don't want to look like a faker or whatever, then down the line, the insurance company, Uber's insurance company here, is going to say, look, you're more hurt because you didn't put on the C-collar. So always do what the paramedics say.
Yeah. Just do what your doctors tell you to do generally.
Simple. And if your lawyer starts giving you doctor advice, go find another lawyer.
Yeah. Yeah.
Ben is in this bad crash, goes to the hospital. He's really badly hurt. We can kind of speed up through Ben's treatment, but Ben recovers as best as he can.
Yeah.
Is that fair?
He has a back surgery, but he recovers the best that he can.
You want to tell everybody how we figure out case value?
Yeah.
Yeah, you want to play?
Yeah.
All right, you to me.
So what do you think this case is worth?
I would not take a back surgery for $900,000. No kind of back surgery. I don't care what kind of back surgery. I wouldn't do it.
Minimally invasive?
No, definitely not. And definitely not evasive. Definitely not invasive. I would not. You're not screwing anything in my back. You're not taking something out, vertebrae, and putting it back, or a spacer and putting it back in. You're not doing any of that. So to me, every day of the week, this case is worth more than $900,000 because I wouldn't trade And I don't think most people would trade money for this injury.
Let's do this. Even if you knew that the surgery wasn't going to, or it was going to resolve all your pain. So you have to go through this painful surgery process. You have to go through about a year worth of treatment before
Do I
the
get
surgery.
to still be worried about the surgery and scared that it may not work?
Yes, those are all things that you get to be worried about.
Yeah.
Yeah.
Those are big worries. Those are really big worries.
We talk to clients all the time, and this goes back to we can't make medical decisions for our clients or even recommendations. I tell people all the time, I'm not going to tell you what you should do when it comes to surgery. Your doctor may say, hey, there's this likelihood that it will help you. There's this likelihood that things will go south and you will get worse. There's this likelihood that you'll stay the exact same. Depending on the procedure, depending on the condition, all of those vary. But at the end of the day, it's someone that has to decide for themselves how they're going to risk those factors or
My
risk
answer
factors.
is always, if it's me, I'm going to wait as long as I possibly can to have a major surgery to make sure I absolutely need it.
Oh, yeah.
But I give the big but I have to realize that if I don't have the surgery, I have to be worried that the jury may think I'm never going to get the surgery and is not going to give me medical bills and money for pain and suffering for being scared about the surgery, having the surgery, recovering from the surgery, all those areas that you're allowed to get pain and suffering. The jury may not value that. They may say, look, it's been 3, 4, 5 years, however long it's been, and you might not, I don't think you're going to have the surgery. So I'm not going to give you money for it. And as long as you accept that and you don't want to have the surgery, don't. Like that's...
Well, and the reason why some juries might listen to that is because this is the insurance company's game plan. They want to take reasonable people's reaction to treatment and throw it against them.
Yeah, and I'm not saying that's right to not, because somebody may last 10 years through pain every single day and then decide to have the surgery. We can't drag out your case for 10 years to find out if you have it.
Right.
So what the jury has to decide is whether it's more likely than not, so whether it's 50+% or not, that you're going to have the surgery. And the defense lawyers, like you say, stand up and go, well, not going to have the surgery, obviously, hasn't had it yet. So that is the competing argument.
Yeah. Or sometimes the considerations for the client are, okay, well, I can go to work at my desk job right now, but if I have this surgery, I'm going to have to take off for 3 to 4 months because I won't be able to sit upright for that long, or I won't be able to do whatever I need to do at my job. So if I get this surgery, am I going to be fired? Am I going to have any money during that time period of recovery? It's not just is this going to make me better? There are real life considerations to, should I get this surgery and can I?
Well, and the other thing that happens, the two other things that happen, or that the two other things that are considered, for long-term success is, one thing is if you're young and you have at least certain kinds of surgeries, you may have to have that again later on. Like, let's take a knee. If you have a knee replacement as a very young person, you're probably going to have another one. So a lot of doctors tell you wait it out as long as you possibly can, so you only have to have one. And then the other thing is, on the flip side, I say to clients, if you don't have the surgery because you want to wait 3 or 4 years, totally fine, especially if you're young. But what are you going to do in 30 or 40 years when you're saying, I had that crash way back when, and that's why I can't pick up my grandkids. That's why I can't walk down to the beach on a vacation. That's why I can't, do all this stuff. So it's a really complicated decision about whether to have a surgery or not.
And at that point, it's too late. 30, 40 years from now,
your case is closed, and hopefully we're being driven around by robots that are safe.
So before we filed the lawsuit, we tried to settle Ben's case before he had substantial surgery and needed more treatment after that surgery. The surgery didn't make him 100% better. It made him a little bit better, but he still needed a lot of treatment.
Never does.
We tried to settle the case for much less than what it ended up settling for, because at the time there was an interest in our client getting the money. He hadn't had all the treatment that he would inevitably get. He wanted us to send this demand, and so we did. Uber said no. Okay, well, that's an easy decision for us. We file a lawsuit.
Yeah, did they just say no, or did they offer some money?
They offered some money, but it wasn't anywhere close to what we thought the case value was.
What, it was like a quarter?
I want to say it was maybe 100.
No, when I say a quarter, I mean it was a quarter of what we asked for.
I think it was.
We were around the
about
$500,000 mark,
Yeah.
right? And they were at one something. So we sent a demand for something like a $500,000. And then the response was something $100,000 ish, a little more than that. So their offer was about 4 times less than what we asked for.
And that offer increased as he started getting more treatment, but so did our demand.
Yeah, well, you were on the phone with the adjuster like every month. So the insurance company has somebody working for them, Uber's insurance company, that's an adjuster, and his job is to, or her job, in this case his job is to kind of keep up with the case, figure out how much the case is worth, and try to resolve the case for less than that. They want to resolve for less. And you were giving the adjuster updates about our client's treatment and saying to him, client's going to go get more treatment. Here's what's happening. Here's what's happening. Here's what's happening, to kind of condition him. So that way we don't just come back in 6 months and go, oh yeah, you've been thinking this case is worth $100 and something thousand. Our client just had this major treatment. Now we want all 900,000. That's a tough pill for the other side to swallow. You don't want to give them the bad news like that, because it becomes difficult to then get the $900,000 when they've had it in their head for 6 months straight that the case isn't worth anything like that.
Yeah. And so we have to file a lawsuit. And one of the ways that we thought we might be able to put some pressure on Uber is to include Uber as a defendant. So in rideshare cases, typically, the rideshare company provides insurance for the driver, but the driver is an independent contractor. According to them.
Yeah, there's a dispute about whether, and the quick law is, if you're working for someone, I'm using that phrase vaguely, if you are working for someone and they control how you do the job, they train you, they tell you exactly what to do, they give you the tools. I'm just giving you some examples. If they have a lot of control over you, you are then an employee. Even if you march around going, I'm an independent contractor, you're still an employee if they exert a lot of control over you.
For purposes of the case and holding the corporation responsible.
Right. So Uber says, and all the rideshare companies say, these drivers for us, they're independent contractors, we don't control them. Well, the most important factor in control is money. Is, can the person, the not employee, the driver in this case, do they control how much they charge for their services? And the answer is no. Uber does. Lyft does. So that is one huge part of control. Does Uber tell you where to drive to? Does Uber tell you who to pick up? Does Uber tell you, you have to keep your car clean, you have to have the Uber sign, like all that stuff seems to really lend itself to the idea that you are an employee if you're an Uber driver. But that issue has not been decided in the personal injury context in any states that we know of. And Uber and other rideshare companies are worried about having that decided. Because if it goes against them, that opens up the idea that they're going to be directly included in every single lawsuit, and they don't want that. And the reason is because this lawsuit, if we don't sue Uber, is just our client versus a guy. And the jury will hear he was driving for Uber, but it's not us versus Uber. And what we want is it to be our client versus Uber, so that the jury knows that Uber's involved and we're not just suing some poor guy who was driving a car.
Well, and that also brings into play why the policy limits are so important. Because if Uber is a defendant, it doesn't matter how much their insurance policy is, because Uber has billions and billions and billions of dollars. We can go recover.
Sort of.
Kind of.
Yeah, I think they still
have a bunch of debt.
Still losing money every year.
I don't know. But they have the ability to pay a lot of money.
Right.
Whereas if there's an insurance policy for their independent contractor, in quotes, driver, that is capped, well, then we have a judgment against the driver. So that judgment can be $5 million. But if the driver doesn't have $5 million, which if they're an Uber driver, they don't.
And we don't want to get $5 million from a dude who's driving an Uber.
Right.
Like he was working for someone else. The company's responsible for their employees.
Right.
Yeah.
We've filed a lawsuit in a creative way to try and add Uber as a defendant.
Knowing Uber would want to shy away from being involved in the lawsuit because they don't want a ruling one way or another. Because if we were to get the ruling that favored us, that they were the employer, everyone in the world now is going to say, well, look at what Mike and Chris did. Let's do the same thing.
Right. And when we filed a case against Uber, we got two things. We got a motion to dismiss Uber or to compel arbitration. And then we got a bunch of paperwork. The paperwork is the terms of service and terms of condition that an Uber rider says yes to, probably only once, that says they accept the terms and conditions to ride in an Uber.
Then this is right around the time that Disney got a lot of press for preventing someone from suing them because of their Disney Plus subscription, something they signed on there, even though they were hurt at like an amusement park and had nothing to do with Disney Plus. I don't remember the details, but like I remember that this was the same time. Like this was, I guess, the popular idea for these companies to do at that point.
And what we have to deal with in these arbitration clauses is our client agreed to use their app, checked the box, but probably didn't know what it says. Doesn't know that they can't sue Uber if the Uber driver gets into a crash.
Do you read the terms and service?
Absolutely not.
Okay.
No.
Yeah.
And in fact,
my thing is if I can't change it and I'm going to agree no matter what, I'm not going to read it.
Yeah.
Like I'm going to, I don't know. I'm going to use Google to search things. So Google, throw up some terms and services. I can't change any of them. There's no like, Mike, make your edits. I agree.
Yeah.
There's nothing I can do.
And Uber knows that you're not going to be able to change it. They know that you're not going to read it. Hell, the entity that we sued, one of Uber's many entities, was not even listed in the arbitration agreement. But it said Uber and all of their subsidiaries and affiliates.
Well, Uber's Razor.
The company that hires drivers is Razor.
Yeah, yes. So I think we at least want to mention to you that Uber is not necessarily Uber. And that's for a lot of companies. Like when you sue Walmart, you don't necessarily sue Walmart. I think here in Walmart, it's Walmart Stores LP East or something. But like you sue specific entities, specific businesses. And Uber is a conglomerate of a lot of different businesses that all work together under the Uber umbrella. So we thought we had some possibility, some potential when we said, well, look, the company we're trying to sue that's involved in the drivers and rideshare is not listed on this arbitration agreement. We have to file the lawsuit because when we get to the point where we say to them, hey, he had the major surgery, here's what his medical treatment history is like, here's what his medical bills are like, here's what his future prognosis is, they won't offer all the money. And at that point, we made the decision with the client that it was $900 or nothing. I mean, it was that we were going to recover on $900.
Or 845 blah, 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 blah.
The 900 or something.
There were so many demands that we made that we had to actually withdraw because we'd say, okay, well, we'll settle this case for $500,000. And then Ben would go get more treatment that he needed. And then we'd look at the bills and we'd say, this doesn't make any sense. Now it's $600. Now it's $650. And it got to a point where his treatment was such that there was no way that anyone in our office could justify settling the case for less than the policy limits.
Can you explain why the tactic you use of being a normal human and not a jerk is actually helpful? Once the lawsuit gets filed, that adjuster we talked about gets essentially at least replaced as the spokesperson for the defense side. And we now communicate with the defense lawyer. But before you file the lawsuit, before we did that, you're talking to the adjuster and you're saying to him, hey, it's not 500, it's 600. Hey, it's not 600 anymore, it's 650, and so on and so on. Tell everybody how you did that and why you didn't do it because I know the answer, why you didn't do it in a way that was like aggressive and like, kind of showboating in a way.
Yeah, because we don't benefit from that in this case where the policy limits are what they are. If there was $25,000 in coverage and we said, we want $25,000 for this case because his medical bills are $200. Well, if the adjuster doesn't pay that and they try to offer us $15, I have no incentive to be nice. That's an irrational decision on their part. And what we're going to do is we're going to go try and get more than that $25,000.
Yeah, that's like a positive for us. If a client ever gets offered in that situation with $200,000 in medical bills and gets offered $15,000, like we're happy about that situation because then we can get more potentially than the $25,000 that we originally were limited to.
Right. If there's enough coverage to apply to someone's injuries, then I want to do everything that I can to make the adjuster's life a little bit easier. I want them to feel like, hey, I didn't really have to do very much on this. The plaintiff's lawyer gave me every single thing I needed to evaluate the case, told me how to evaluate it, told me how to go talk to my supervisor about how they should think about it.
What to write in his report.
What to write in the report.
We write a lot of reports informally. Dear adjuster, if you're writing a report anytime soon, you may want to include this language that we think is really helpful for your superiors to know.
I ask this of adjusters and I ask this of defense lawyers all the time. What can I send you that will help you talk to the person on the next rung to get higher settlement authority?
I had a conversation with your old boss. Well, sort of your old boss. Okay. When you worked at a defense firm.
Yes.
So we have a case with him, and I called him and I was like, so what are the problems? Like, what are my problems? And he goes, oh, you got 2 problems. And he tells me the 2 problems. And I go, oh, okay, I can solve one of those problems. Give me a week and I'll give you an answer. I didn't know that was a problem. The other one I go, okay. Yeah, I mean, that we have a disagreement between those 2. But now I can report back to my client and I can know going into the trial, these are the problems that they have with our case. If I can resolve them, maybe I can settle the case for the right amount. If I can't, I know going to need to address these at trial. Good lawyers on the other side will tell you what the problems are. So that way you can at least understand what's going on, because if you can cure the problems, they want to know that before trial. They don't want to bring up what they think is like, a great argument at trial in their opening statement. And then I look at you and I go, oh yeah, well, we'll just ask this witness this one question. That whole argument they made just goes away. They don't want to look stupid.
Right. And if you're honest with the adjuster in a case like this where there are a lot of insurance limits and you tell them what's going on with someone's treatment as it happens, your offers are more genuine and they get a better response if you make that adjuster's life a little bit easier than, hey, we're arbitrarily increasing our offer because we just think it's worth more, or we are trying to stick it to you. Those adjusters don't want to be pinned up against a wall. They want to be able to say to their supervisor, hey, this plaintiff's lawyer told me this is the treatment and that it was going to continue. Then they told me this was the treatment and it was going to continue. I asked you for X amount of money way back when, and you said no. Now they want even more because what happened is exactly what they said would happen.
Yeah, I mean, we've handled so many rideshare cases. I'm going back to rideshare on this one. We've handled so many rideshare cases that there is, and we know that there is a special insurance group that handles high-value rideshare cases for the certain companies. And one of those guys is in Colorado. And I have gotten to know him pretty well over the years because he is typically the supervisor for all of our cases. Because that's, they want to work with the same, they see the same lawyers and they want to work with, matching the right adjusters with the right lawyers. So he now comes in most of our cases when it's those situations. And he calls me up on my cell phone and says, what's going on with your client? Like, where do you guys see this case going? And I tell him honestly, here's what I think. I don't tell him too much. I don't tell him too little. I'd say, here's what's going on. Here's what I think is going to happen. Here's what I think you should do. And over the years, I think that's a really good working relationship because in a lot of situations, our clients are one-off people. They get hurt once. They're only going to get hurt once, thankfully. And they have one case and then we will never represent them again. And we don't want to. But we see the same lawyers, we see the same adjusters, we see people in our world over and over, and the credibility that you build up over the years helps. So next time, I bet you, when we have a case against Uber like Benz, and we potentially have that same adjuster, or we have that same insurance company, and we say, look, what are we going to do? We're going to say, look at what happened in Ben's case. We told you that this, so why are you going to do another Ben's case? Just let us settle the case now. Let's not go through this charade for 6 months. So the case does not settle during this stage where we're trying to get the adjuster to understand what's going to happen, that there's going to be a major surgery, that the case is going to have even more value. And I mean, there is a little bit of us at that point that we aren't 100% sure the client's going to have the surgery. I mean, there's always that possibility that he doesn't. And leading up, I don't want people to think that we were trying to settle the case when our client was definitely going to have this surgery. We were trying to settle the case because our client said, if things keep going, I'm probably going to have the surgery, but I still want to settle my case now. I mean, he still wanted to settle it. So we filed the lawsuit, and then we get into, the idea of we're working with a defense lawyer who's now the go-between, and we're still trying to get the $900,000.
In a case like this, who was at fault for the crash? was pretty clear. And they certainly couldn't blame our client, who was a passenger. He did the responsible thing. He got into an Uber. He wasn't driving.
We get to the point where we make the offer because we feel good about it. We make the $900,000 offer, and all we say to them is, you give us the $900,000, we will not sue you any longer, and we won't sue you again for this. And they say yes. So I remember you and I then talking about how we're going to make a video. Like, oh, this will be fun. We'll finally be able to make an Uber video. And as far as we know, just a little bit of a lawyer disclaimer here. As far as we know, this is the largest non-confidential settlement relating to Uber. As far as we know, we've never heard of a larger one. Like if you go on our website, you can see that we have
confidential settlements
against rideshare companies, but that's all it says. But as far as we know, this is the largest one in the country that we've ever heard of that we can say Uber. Yeah. And then things kind of took a little bit of a detour for a while.
Yeah. At some point, they realized that they had agreed to an offer that did not include confidentiality. And tried to add it.
They sent us over and said, here are our terms. And we're like, no. Those were our terms. You don't get to now. You've already accepted that. You don't get to pick new terms.
Right.
We're not going to agree to any of that stuff.
Yeah.
But we did offer. Now, before anybody goes, oh, you just wanted to make a video. That was not our point. We definitely were like, oh, cool, we get to make a video. But when Uber comes to us and says, we want confidentiality, we say to them, sure, so long as you pay more money.
Right.
And we say to our client, hey, this may be a valuable thing.
Right.
Confidentiality is worth something to them. Our client doesn't care if he can or can't say Uber.
Yeah.
Like, why? It makes no difference to his life. So we say to him, hey, we might be able to get you more money because we can convince them to agree to confidentiality in exchange for paying us more. That may or may not have happened in other cases with us before where we've been able to say, yeah, if you want confidentiality, you have to pay more.
Right.
So we decided to try that plan that we may or may not have done before.
Right.
In rideshare cases.
But in this case, we had and it's the precise dollar figure is literally down to the cent, but we got every cent that we could that was remaining on the insurance policy. And so
Uber would have to come out of pocket.
Uber would have to pay something to get confidentiality.
Or Uber would have to get real mad at their insurance company or their lawyers for agreeing to something that didn't involve confidentiality and making one of them pay. I mean, that's the other option.
Right.
Which sounds ridiculous, but that shit happens.
Yeah. And they weren't willing to do that.
Yeah.
So
why would we give them something for free?
Right.
We're just going to tell our client, now you don't have to worry about not saying Uber, and we're going to sit here and, talk about it.
And, we talked about at the beginning why we would take a confidential settlement. It's not good for public policy. It's not good for the public at large that they don't know what the value of a corporation's harm on an individual is, but it's good for our client individually.
And that's what we have to think about. That is our sole goal. We don't get to choose, we want to do something for the greater good. We have to ethically obligated to put our client first.
But now we have this opportunity because they didn't read the settlement offer that we sent I guess they didn't read it critically.
I don't have a good answer.
Yeah, I don't have a good answer either, that we can talk about it. Now, let's talk about if they had said no, what position that would put Uber in.
Okay.
So
if they had said no to our settlement offer.
Yeah. So
we send a special settlement offer and they say no, then
Uber could say, well, we want confidentiality and we're not going to settle without confidentiality. But Uber, as we've talked about, is not the defendant in the case. The defendant in the case is their driver. He is an individual. And so they're putting Uber's interest ahead of the driver's interest. In other words, they're saying, if they go get a $2 million verdict against our driver, well, he's got to pay for anything outside of what our insurance provides. He's going to have to declare bankruptcy. He's going to have his wages garnished. That's not our problem.
Can you imagine you're that driver and you're going, wait, they offered to settle this case for $900,000, but you guys wouldn't because even though they're suing me, you didn't want them to be able to say Uber? What?
Yeah.
But that is the scenario. In this case, had they not accepted the offer, the driver would have been hung out to dry. And that's not fair to him.
And he would have had no input into their decision as to whether they should accept our settlement offer.
I guess I'm in a good mood. So are you. But this kind of goes with the theme of, we're not trying to destroy stuff we don't need to destroy. We would prefer to sue Uber for a lot of reasons. One of them being, if you're working for a company, I don't want to sue you, the employee. I don't want to stress you out. I don't want to make you worry. I don't want any money from you directly. I want your company to pay the full and fair amount of the settlement or whatever it is. I don't have any interest in ruining, hurting, destroying, whatever word you want to use, some guy's life who just happens to be working for making a mistake, for, running the red light, not using their blinker, not seeing that other car coming. Like in 99% of our cases, the person who caused the crash, they weren't trying to get hurt that day. They weren't trying to hurt anyone. They just made a mistake. And I don't want to destroy their lives in any way. I want their insurance companies and their companies to step up and do what's right, not only for their own employees, but by doing that, they're also doing what's right for our clients.
Right. And when Uber says, if they were to, in this case, say, I'm not going to accept that settlement agreement unless we add confidentiality to it. For Uber.
So you can't say Uber. Even though you sued Steve, Ben versus Steve, Uber's like, yeah, but you can't say Uber. Well, Uber, why can't we include you in the lawsuit? You're not even involved in the lawsuit. You made sure of that.
So that's a good point. Let's run through this really quick. Uber doesn't want to be included in the lawsuit.
Yep.
They want you to arbitrate with them.
Sure.
Because it's
confidential
better
and confidential.
Confidential. Arbitrate with them because it's better for them. Then they want to be included at the end of the case in any confidentiality agreement in order to settle the case. So they want to get out of the case.
Could you imagine?
But they don't want you to be able to say that they want to be out of the case.
I mean, could you imagine if one of our paralegals got sued while she's driving to go pick up something? Maybe we had some vendor make us a big board that we're going to use at trial, right? So she's going to drive and pick it up and she hit somebody. God forbid. It's never happened in our office where our employees have ever gotten into a crash. And imagine she gets sued and our insurance would cover her because she's on the job working for us. Can you imagine if I said to her, I'm going to use a name. Imagine if I said to Casey, because Casey is the scariest person to me. I think she would just beat me up. Imagine if I said to Casey, hey, I know you got sued while you were working for us. Sorry. I am not going to agree to settle your case, though, unless it's confidential as to me that my firm and us. Your employees got to be like, what are you talking about? I'm the one getting sued, not you.
Yeah.
And Uber here is literally going, yeah, we're not getting sued and we don't agree to get sued, but you got to protect us, driver who works for us that we don't pay very well and we may leave out to dry. That's not disparaging, right? That's general knowledge, general thing,
knowledge.
Not disparaging about the case.
Yeah.
I think we're good.
Yeah, we're all talking about in the context of this case.
Yeah.
What happened and what may have happened.
And Uber in general, I can say I don't like Uber as a company.
Yeah.
So the case eventually settles for the 900, keeping to our kind of theme here. We did not call up the adjuster and go, told you so, told you should have done it. But looking back, I hope he knows we could have settled 6 or 9 months earlier for the same amount. They wouldn't have had to pay legal costs. Our client wouldn't have had to wait 6 to 9 months, and we'd be on to the next one.
I think it boils down to the adjusters used to being able to lowball their offer and the attorney on the other side not take the case into litigation or not being willing to try it. And so when you're choosing a lawyer, how many cases they try, how often they litigate, that type of thing, it matters even before a lawsuit is filed. Because if the insurance adjuster knows, hey, there's no way that Joe Schmo is ever going to litigate this case against me or try this case against me, so I can offer them way less because they don't have an alternative. Hiring that person doesn't do you any service. So let's take Ben's case, for example, though. A lot of the calls that we get, they say, how long is this going to take? Anyone that tells you, I know how long your case is going to take is lying to you, right? Because when Ben first called us, we didn't know that Ben needed surgery.
Yeah.
We didn't know that Ben needed injections. We didn't know that Ben needed this very specific post-surgery treatment that burnt the nerves in his low back so that he wouldn't feel pain. All of that stuff happened.
Radio frequency ablation if you're Googling at home.
Exactly. All of that stuff happened over time.
And during that time, we're trying to follow Ben's wishes and settle the case, but we're also cautious because we don't want to settle it and then have him come back to us and be like, oh, actually, it's way worse than what my doctors thought. Reopen our case. You can't reopen your case.
Right. This crash happened in May of 2022. It settled in December of 2024. Now, we could have settled it for a quarter of what we settled it for back in July, August of 2022, where we didn't know what our client's injuries were. It was just a quick buck. Would have made us some money. Would have made him some money.
That's malpractice.
That's malpractice.
Malpractice. I would venture to say more than 50% of lawyers would have settled this case for $150,000 within the first 6 months.
Right. So do you want, as a client, do you want money quick? In some circumstances, yes.
Yeah.
And there are good reasons to want money quick.
And
or
we
need
get
money quick.
And we get that. If Ben's case was only worth $160,000 and we're sitting here being like, hey, we could have settled it within 6 months for $150,000, but we went another year and a half working hard to get him $160,000, that would be stupid. Like the time value of money, that's stupid. And we wouldn't do that. When we know the case is now worth $500,000 and then later worth $900,000, that's when the money makes sense to wait for.
Right. But at the same time,
because you and I are waiting for our money too, because we get paid out of these cases. So I don't want to wait 2 years for, my share of $10,000 when the cases, should be settled. Like we don't want that either. And that's why I think the system of hiring personal injury lawyers without paying them is really good in a lot of ways when the lawyers have your best interests in mind and we're not worried about, waiting 2 years to get paid if the case warrants it, because we're thankfully wearing nice suits and we're not worried about every check that comes in. There are a lot of lawyers who live and work check to check, and they need that check to come in. So you had brought up results. One thing that I could probably count actually on my one hand, the number of times a potential client has asked me for this, and I always think it's a really good idea, is can I talk to any of your former clients? If you're building a house, you're going to be like, hey, contractor, I got to talk to some other people that you built for. If, whoever, a lot of recommendations are really common. Real estate agents. I mean, I don't know why it's in the property world. You talk to other people. I am surprised more potential clients don't say to us, can I talk to somebody who had a similar case like mine? They can tell me about the experience.
Yeah.
Because if they did, I'd be sitting on the phone with them. I'd put them on speaker and I'd be like, okay, hold on a second. Wait, I'd be texting an old client being like, hey, can I introduce you to Cindy who wants to talk to someone to ask them about us? I'm surprised people don't do that. And any lawyer who doesn't, isn't able to say to you, well, I've got to talk to my former client first because I have to get permission for them. And because of confidentiality, like we can't just give you their number, but I will make this happen. Any lawyer that's not like, oh, I'll make it happen for you, they got a problem.
And if you ask that question of the lawyer and they can't think of one client who is willing to say that had a similar case, you should probably not hire that person.
Yeah.